We're going to move straight on to David's presentation, and we'll have plenty of time, I assure you, at the end of all the presentations for discussion. David, I know you're probably will be speaking about the work that you've been doing following your role in the negotiations for the new set of international guidelines, which I won't go into the detail on because I'm sure you'll be speaking about those, the guidelines on the domestic facilitation and regulation of international disaster relief and initial recovery assistance. And David's work since then to promote their implementation. And I know you have some comments on Paul's report as well. So I'll hand over to you. Thank you very much.
Great. Thanks very much. Sarah, I'd also like to thank ODI and Paul and our friends here at DFID for including me on this panel. It's very generous to accord some of your time, and to those of you who have some sort of consciousness left here at the end of the day to do so, I'm very grateful for that. I'm going to talk a little bit about the Federation's effort that predated the tsunami, but very much had an impetus from the tsunami, and is very much related to a lot of the issues that Paul has brought up, but doesn't deal with the entire scope. And it's really looking at the legal angle more than anything. But maybe before I do, just taking Sarah's invitation up, just to sort of make a couple of comments on the report. We thought it was an excellent report. We certainly recommend it to those of you who have not yet read it. And the overall message of paying more attention to the domestic side, which is something that the Federation has been trying to bring to the attention of the international community for quite some time, we think is very important. We find that the report does a very good job of bringing a balanced view to the sort of pluses and minuses of working more carefully together with governments, particularly in a natural disaster setting. And this is something that also we found in our work, both particularly from the legal side, that first of all, the law at the international level is very different when it comes to conflicts and natural disasters. And the dynamics are also different on the ground. And it's for those reasons that you can't use exactly the same mode of operation in a non-conflict setting. But unfortunately, many international actors don't make that leap. So just to give a little bit of background about how we got involved in this, it was in 2001 that the Federation sort of took up the issue of looking at the legal regulation of international relief in disasters, natural disasters. After an article was written in our World Disasters Report, essentially noting that there's this globally accepted, comprehensive framework of international law for conflicts, but really nothing like that for disasters, even though many millions of people are affected by natural disasters every year. Natural disasters affect so many more countries than our conflicts. There's tremendous amounts of money and effort that goes into international assistance efforts, but the regulation is pretty dispersed, not very well known, and certainly not discussed very much. So the initial effort was just to try to figure out and collate and figure out what exactly was there. We also, under the framework of our program, did about 24 case studies in various parts of the world. In the beginning, just kind of looking at what the national law was, dealing with the international response, if they should ever need it, looking also at the international and global norms that exist, and then increasingly, and particularly after the tsunami, looking at it as an operational point of view. What are the regulatory issues that show up in disaster settings? We did surveys, we held meetings, we've been sort of concentrating on this now for a couple of years, and particularly after the experience of the tsunami, this kick-started the notion of negotiating a new set of guidelines to handle these issues. And those were adopted in 2007. I'll talk about them more in a second. And since then, our program has been doing less research and more in the area of technical assistance and trying to get governments to use these guidelines and other actors to realize not only that the guidelines are there, but also lots of other international documents that very few of them have used before. Part of the context for this is the realization that thanks to the effects of climate change, we're seeing a lot more disasters already, You can see in this chart there's already a doubling of natural disasters just in a period of 16 years. Climate change is not something that we just worry about in the future. It's already impacting our operations. Climate change also changes where these kinds of hydrometeorological disasters occur. Governments, countries, territories that never had such disasters in the past now are starting to see them, starting to see bigger disasters than they had seen before. So governments that would never have thought about asking for outside assistance in the past might now be faced with it. At the same time, as Paul's mentioned, governments are facing an increasingly complicated sort of international relief community, which was limited, in the 19th century essentially to the Red Cross and to other states, and over the years has gotten much bigger. And it's really only over the last couple of decades that it has exploded in many ways. And we see the tsunami was an extreme case, but it was not completely unusual, because we've seen the same situation after Hurricane Mitch in the Americas. We see it in other areas of the world as well. And it's not just that we see more states that are not only wanting to give funds, but they want to send their boots on the ground, preferably military boots. So there were over 24 militaries that responded to the tsunamis, and we're seeing much more emphasis behind that in the future. More of our national societies are doing international work than wasn't the case in the past. UN agencies are now more involved in natural disasters than they ever were. UNHCR, for instance, got involved after the tsunami in Indonesia and Sri Lanka with people who were not even necessarily displaced because they had the means to do so, and a lot more NGOs. This chart sort of shows numbers of international NGOs that were sort of tallied in Gujarat, 100 of them, 120 after the BAM earthquake. In Aceh alone, after the tsunami, there were 200. And according to the figures I've heard from the field, it was about 189 after the Padang earthquake. Dozens and dozens of urban search and rescue teams. The numbers of sort of outside organizations not already in the country sort of flowing in other areas, particularly in the Americas, is less, but the phenomenon is fairly familiar wherever you go. And there's also more non-traditional actors getting involved, church groups, private companies now, and that have people on staff that do nothing but this kind of work. Even private organizations sort of are seeing major disasters on CNN and wanting to get involved and showing up personally. And governments, for the most part, when it comes to the legal side, are not prepared. Very few governments have any detail in their law at all about receiving international assistance and what they do with it once it arrives. And this is not limited to the tsunami countries, although they certainly were in this situation. Both in Indonesia and Sri Lanka, to change their entire institution for dealing with international aid over and over again over the course of the tsunami response. But the same phenomenon happened in the U.S. after Hurricane Katrina. I just attended this civil protection forum in Brussels, where we had the head of the Italian Civil Defense Agency talking about the same experience they had after the L'Aquila earthquake. This is not a problem that is limited to the developing world. The research that we did, the consultations we did, came up with a set of common regulatory problems that are not that surprising, but for some reason haven't really been addressed very well for the most part. Paul has mentioned some of them, and there are two types. On the one hand, we have barriers to international actors coming into the country and providing their assistance. Sometimes they can't get, sometimes the government just says no, as was the case after Cyclone Nargis. But actually in the natural disaster setting, it's extremely rare. Usually the government either says yes or says something rather vague, and the actors start showing up. But even though there's a formal or at least tacit acceptance, that doesn't mean your individual relief workers get visas. And more often than that, they do get tourist visas, or the visas are waived, but then once they get in, they're working in the country for pay, which is legal on a tourist visa. And then sometimes, in a major operation, they start hiring local staff, also illegal. And then the local staff are on the black market, working for an illegal immigrant in the country. They don't have work permits. And both Indonesia and the tsunami, they had to fly in and out of the country over and over again to renew their visas. Some of you may have had this experience. And it wasn't just the NGOs. This also happened to the Red Cross. It happened even to UN agencies. Some government agencies had the same experience. Customs is a huge problem, as many of you may already know, in disasters. for instance, in Indonesia, after the tsunami, there were 400 containers of relief still in customs custody 1 year after the tsunami hit, including body bags, food, other things that were, of course, no longer of any use. When the Marmara earthquake hit Turkey in '99, the clearance was so slow that a rule kicked in that said that the goods were considered abandoned, and the government nationalized them and gave them to the armed forces. There are certain problems of essentially having a prepared system for dealing with a large influx of outside assistance that happens in a lot of countries. Taxes can be a major issue, even though it's very rarely discussed. Oxfam was required to pay $1 million worth of customs duties on the vehicles it brought into Sri Lanka after the tsunami. On the other hand, these kinds of issues show up particularly for NGOs that don't have sort of recognized status in international law. It also happens to Red Cross societies that are working internationally, Red Cross societies. But if you see these kinds of delays and these kinds of barriers, often it's because of the headaches that the international community is itself causing. And Paul's already gone into some of this, but a lot of the customs delay had to do with goods that were showing up that were completely inappropriate, truckloads of expired medicines. This is not just for the tsunami, although it was a major problem there, but it's also been experienced in Africa and in Eritrea. In the 90s, they received 30,000, in one disaster, 30,000 bottles of amino acid, tons of aspirin, which had to be burned as toxic waste. The agencies sending just goods because they have them, expired food, governments insisting on sending field hospitals when everyone who's going to die has already died after the tsunami. There's an enormous problem of a lack of coordination from the international side that contributes to the barriers on the receiving end. From our research, we're not able to really say precisely whether this has led to people dying. But it's absolutely clear that this is leading to reduced access, that it's making aid slower, that it's making it less efficient and more expensive. So this was the background of why we started working on these guidelines that are up on our website if you're interested to see them. I have a couple copies here. And the guidelines are essentially recommendations to governments about how they can prepare their legal systems for the common problems in international relief, so that they know what they're going to do and they have the rules ready to do it when the time comes. A lot of governments assume that they will just work this out when the time comes. They'll give themselves some kind of emergency power. And the tsunami experience in particular proves how difficult that is, to make up an entire system, entire regulatory system on the fly, when your own actors are themselves dealing with a major catastrophe. The guidelines are based on existing treaties and resolutions and guidelines that are out there that are underused, and they seek to sort of balance these two issues of making sure that aid is quick and effective, but also that sovereignty is observed. So I won't go into any more detail, but just to say, essentially, the guidelines are recommending to governments that they should be giving external governments, humanitarian organizations, and other actors that they want to come into the country and provide assistance, a package of legal facilities that they need to do their work. If you're a UN agency, this is called privileges and immunities. We don't use that term because it's sort of a loaded term in international law, but essentially it's along those lines. It's kind of special legal capacities that you wouldn't have otherwise coming as an outsider to the country because you need to do this urgent relief and recovery work. And this has to do with getting visas, getting work permits if you need them. For instance, having your qualifications if you're a doctor or a medical worker quickly recognized in the country. Because if not, of course, and you do any medical work, you're inevitably violating local law. It talks about customs, tax, and essentially the domestic legal status, having some kind of temporary legal status for outside NGOs in particular, so that they can be well integrated into the response and also not be essentially outside of the law in a sort of netherworld that happens after a lot of major disasters. At the same time, the guidelines look to the other side of the equation, which is the problems that the international community is causing. And so it insists that all the international actors who are providing assistance have certain responsibilities. And it sets up a bit of a hierarchy about them of some things that the international organizations should always be expected to do no matter what: abide by law, abide by humanitarian principles, coordinate with domestic authorities, and others that are on a sort of, to the greatest extent practicable, to the extent that they can possibly do it. They should be abiding by sphere, they should be involving their beneficiaries, they should be transparent in terms of their funding, making sure that all the staff they use are fully trained. And then the guidelines recommend that at least when it comes to humanitarian actors, the governments should link these two issues together. They should have some kind of registration process, which a lot of governments already do, but that they should say, you're going to, as a registered organization, receive these legal facilities, and in exchange for which we expect you to abide by these standards. And if you don't, we're taking them away. And this is, to some extent, to respond to Paul's, I think, very prescient statement that if the international community doesn't seize the sort of debate about this and provide a relevant and workable solution to governments that are becoming more assertive in trying to regulate outsiders, then they will not necessarily use the standards that we would have come up with at the international level. And so this is where this is coming from. We've been very fortunate in terms of kind of diplomatic level recognition of these guidelines. They were adopted by all the state parties to the Geneva Conventions at the International Conference of the Red Cross and Red Crescent in 2007. And also we've had 3 General Assembly resolutions last year where states are urging themselves to use the guidelines. And there's sort of emerging interest in them also at the regional level, where we see a lot of the kind of energy, essentially, to solve a lot of these problems. And the ability to get past some of the politics seems to be in these regional organizations. So ASEAN, for instance, adopted a very interesting agreement after the tsunami that has a lot of elements of the guidelines. And they're using the guidelines as standard operating procedures for carrying out some of their post-disaster work. APEC has put it into its new disaster management strategy. A lot of these regional organizations that weren't involved in disasters before the tsunami now want to be, and it's just an excellent place to bring up not only issues of trying to improve facilitation and regulation in general, but also to highlight the role of the non-state sector, because traditionally the regional organizations only talk to each other as government-to-government aid, and it doesn't have to be that way, as the ASEAN agreement proves. Here's just a couple of examples of what are going on in the guidelines. We put out a 2-year sort of progress report recently. It's up on our website if you're interested. We don't have a flood of new laws in place, but we have a couple that have been passed, mostly at the regulatory level. Indonesia, after years and years of negotiation of its law, starting well before the tsunami hit, finally adopted one that had about 2 paragraphs about the international response. But it then did also adopt a set of regulations that had a lot of good elements drawing on these guidelines into it. Unfortunately, they haven't solved all the problems, partly because a sort of competing regulation was adopted just last year through the Home Ministry that kind of went counter to the original regulation. And this is something that's still being worked out. The Indonesian Red Cross and the National Disaster Management Agency are working on now their own set of domestic guidelines to sort of make more explicit what's still a little bit unclear in those regulations. But it's at least a step forward. We see a number of regional organizations, as I mentioned, that are starting to use the guidelines to develop their own sense of guidance and standard operating procedures. And there are about a dozen formal review processes going on right now, and about another dozen that are just about to start up in various parts of the world, where governments are looking at their laws in the light of the guidelines to see if they're ready to handle these issues or not. Because most of these issues are not in the national disaster law at present, it's a bit more complicated than it otherwise would be. It takes a bit of time. The guidelines were very focused and very narrow because it was something that we were trying to negotiate at an international level, and it really only focused on the relationship and the regulation of international assistance coming into the country. And there are a lot of issues that they don't touch that are really very important. The tsunami certainly brought them out, and other disasters did. And I think that, for instance, this nascent idea of a right to safety that you see in the prologue to the Hyogo framework, that this notion that governments have responsibility to keep their citizens safe from disasters, is an important issue, and something that I think will be an opportunity for more advocacy and more work coming out of the Copenhagen summit that's going on right now, because this notion of adaptation to climate change is going to hopefully include some notion of disaster risk reduction. Protection issues are something that the international community is only just seeming to wake up to in the natural disaster setting and just in recent years. There's quite a lot more that can be said about that, both in their own programming, but also together with governments. And there are a lot of legal issues that are related to the kind of recovery stage, and particularly issues of title, inheritance of land. The Federation, a lot of agencies got more involved in reconstruction after the tsunami than they ever had been, and these issues suddenly became first and foremost for them. So with all of that, I'm going to spend just one last minute responding a bit to how the Federation has tried to learn some of the lessons that were described from its own programming, some of the lessons that Paul was urging in his report. The Federation, as I'm sure you're all aware, it's the sort of club of all the 186 national societies in the world, and our major purpose is to serve our members and not to serve their governments. And so this, normally we work through them, but we found particularly when we were working in the tsunami operation, that we're doing all this construction, not only of buildings, but also of wastewater systems, and other kinds of infrastructure, that it's of course impossible to work outside of a government structure when you do that. And we were able to turn around. We originally, in some of our projects, went in just essentially replacing what the government could and should have been doing. And we were able to start turning that around, particularly in Sri Lanka, and then also in the Maldives, and essentially directly funding local authorities as implementers of these projects, and making sure that they were directly involved in it. So this, excuse my pronunciation, this Duva Varu project in the Maldives, where essentially the entire island was relocated to another island, 4,000 families. Everything was built on this space that wasn't there before. The local government actors were essentially the ones who carried it all out, with the Red Cross acting as essentially as a donor and as a monitoring function and giving expert advice. And that worked out really very well. And the other thing that we're emphasizing as a sort of lesson learned into the future is to really push this auxiliary role of national societies that Paul already mentioned. This notion that they are linked to their governments and that they are there to support them and to provide them with expert advice and can be a sort of conduit to the international community. So thanks very much.